He hasn't joined yet.
Mr. Eastern just joined. I don't
Yeah,
know.
he's here. He's here.
Uh, he did, but I cannot see him right now.
Shivani,
Yeah,
please
he's
keep a check on this. I can see all other participants, but I can't see Mr. Jain. Please keep a check on this.
Mr. Eastern is here.
He's
Okay.
in the meeting list. You can see.
Uh, Each sir, could we please request you to turn on your audio video and check the microphone, please? Ashwini sir, there is background noise from your side. Could you please rejoin? Good evening, sir. Each sir, can you hear us?
Yes, I can hear you.
Thank you, sir. Thank you for joining. Ashwini sir, could you try your mic now, please?
Yeah, is it still there, the noise or
No,
some
sir. It is
background
much
voice?
better.
It's
It is
much
much
better.
better, sir. Yes.
It may be probably a voice or the noise being created by the ceiling fan. Unfortunately, there is no air conditioner in this room, so the fan is turned on. I apologize if this is really very uh, you know very bad sound. But it's not too much. Smriti, is it fine now?
Yes, sir. It is completely fine now. Yes, sir.
Okay, thank you.
Sir, with you again.
Yes, Smriti, we must start now.
Thank you, sir. Thank you so much, sir. Vanshika, over to you.
Hello, can everybody hear me?
Yes, Vanshika, we can hear you.
All right. Thank you, Samriddhi. And a very good evening to everyone. Thank you for joining in. This is our first webinar as a newly formed committee for this academic year. I would like to thank all the faculty and student members for their diligent efforts towards its fruition. Our professor in charge, Professor Dr. Mahavir Singh Kalon, could not join us for this meeting, but sends us his warm welcome. On behalf of LC2 and the Placement Committee, it is an honor to be hosting such an illustrious panel for the discussion on career opportunities in alternate dispute resolution and its scope for future. In the last couple of years, the Indian government has started investing in and popularizing the methods of ADR as they are more cost efficient and effective. They are more empowering as they maximize participation from the stakeholders in a neutral environment situation for all. India's first international arbitration center was set up in Hyderabad in 2019 by Honorable Chief Justice N.V. Ramanna, where he made the following statements. Arbitration and mediation have a long history in India. Recently, they have acquired prominence across the world as methods of dispute resolution. ADR methods are beneficial to the parties due to various reasons: low cost, speed, more control over timelines and process, the autonomy of parties, a more comfortable environment, and a non adversarial nature. I would also like to take the liberty of quoting Ms. Sandra Day O'Connor, former Associate Justice at the US Supreme Court, in the praise of alternative methods. The courts of the country should not be the places where resolutions of disputes begins. They should be the places where the disputes end after alternative methods of resolving disputes have been considered and tried. I would now like to hand over the center stage to Dr. Ashwini Civil, Assistant Professor in IP and IT Laws and an integral part of the Placement and Internship Committee. Sir, please take this opportunity to welcome our esteemed guests and the students of LC2. Thank you.
Thank you, Vanshika. Thank you, Samriddhi and the entire team. I'm really glad as a teacher, and I'm a proud teacher of all these students who have made it possible to convene such an interesting, such an interesting session in short span of time. It's hardly a week ago we interviewed these people and constituted a core committee for the placement cell for this academic year. So it's heartening to note that the committee chosen by us is working tirelessly, and in a week's time they have brought the fruits, and they have organized this interesting session on ADR. I am glad in absentia of the professor in charge of Law Center 2, Faculty of Law, University of Delhi, and in absence of the convener of the placement committee, it is my onerous duty to first of all extend my deep gratitude to all the esteemed guests who have joined us here, and also to extend my heartfelt gratitude and welcome to all participants, in fact, all the students who have joined enthusiastically this particular event. At the outset, I would like to introduce to my esteemed guests the notable and noteworthy achievements and the milieu of the Law Center 2, Faculty of Law, University of Delhi. We are not a new institution. Faculty of Law, University of Delhi is a premier institution in the country. We offer a full-time 3-year LLB program, and we have a glorious past of 50 years. In fact, we are celebrating the golden jubilee of our center. The classes used to be conducted in the evening earlier, but now the classes are in the morning, and it is one of the most sought after centers out of the 3 centers run by Faculty of Law, University of Delhi, because of the timings, because our timings now are same as of the campus law center. And it is my privilege to inform my esteemed guests that since we came to the North Campus and since we started, the morning classes beginning at 8 o'clock in the morning till 2 o'clock, last 4 toppers of Faculty of Law, University of Delhi has been from Law Center 2. The toppers of the entire faculty are from Law Center 2. And one more interesting thing is that all 4, I need to correct myself. Out of 4, 3 were girls and 1 was a boy. But consecutive 4 years, we have been topping the Faculty of Law. Our students have been fetching the maximum marks and maximum gold medals in Faculty of Law, University of Delhi, surpassing the students of Campus Law Center and Law Center 1. These are 2 other centers run in the same premise here, housed in the North Campus. Most of the guests are aware about the composition of this institution, but some are, I believe, are unaware. So I felt like informing them that there are 3 centers for the administrative convenience, but the faculty is one and the same. There are 3 centers like Campus Law Center 1, and Law Center 2, under or being run under the aegis of the Faculty of Law. Well, so far as the noteworthy achievements in the past 50 years of this center is concerned. We had the privilege of producing a lot of bureaucrats, police officers, military officers, and definitely the High Court and Supreme Court judges. We had the privilege of being headed by the top law scholars of the country, such as Professor Upendra Bakshi. He was the professor in charge of Law Center 2, and then he went on to become the Vice Chancellor of University of Delhi, and then the Professor Emeritus and visiting faculty at a lot of international universities, including the present assignment where he still teaches at the University of Warwick. He's a well-known jurist and former Vice Chancellor of DU. We had the blessings of Professor Tahir Mahmood, who subsequently became Chairperson Minority Commission, Professor A.K. Kaul, who was elevated as the Vice Chancellor of National Law University Jodhpur and National Law University Ranchi, Professor Gurdeep Singh Bahari, who became Vice Chancellor of National Law University Lucknow, and Professor Poonam Pradhan Saxena. She is present a second-term Vice Chancellor of National Law University Jodhpur, and Professor B.T. Kaul, who is presently chairperson, not presently, but he was the chairperson of Delhi Judicial Academy. Perhaps I think so that he recently superannuated from that post an year ago or probably 2 years ago. Well, this is about the center. I don't want to waste time on discussing about and telling about the center. Then coming to the placement and internship committee. Well, it is a professional body incorporated for facilitating the recruitment of country's best minds. And I take pride in telling you that the country's best mind definitely comes here. I have been teaching these students for the past 1 decade or more than 1 decade. It's been 11 years now I have been associated with this place. And I believe I have been to traditional university as a law student and also to a national law school as a LLM student, and had also gone for my doctoral degree to another central university in India. But what I find here is altogether different. The kind of student and their backgrounds we have here, it is divergent and vibrant. We have students coming from different set of disciplines. They are, many of them are science graduates, many of them are commerce graduates, many of them are even working professionals in different fields. So we have a very divergent group, which I believe makes it altogether a different institution than other law schools in the country. This is something rare in this institution. Second rarity which I have found as a law teacher here in this institution is the syllabi, the course curricula which is taught to these students is par excellence to my understanding. I think that the kind of elaborate and extensive case material or case study teaching which is imparted is unparalleled and is definitely unique if it is compared with many of the institutions in the country. Recently, the law schools have started adopting this pattern, the Socratic method of teaching, but we are the pioneers, and our model is being imitated in most of the law schools and the other law universities in this country. Well, this placement committee, we did not have the placement committee in place for the last couple of years, specifically during the COVID times. The reason has been the online classes and not meeting very frequently with the students in past 2 years specifically. So now we have this placement committee in place, and we are very hopeful that this placement committee will bring laurels, and many of the students who are worthy, they will get placed into different institutions, law firms. This is a purely student-driven, but mentored and supervised by the teachers. I am one of the committee members here, along with my worthy colleagues, who probably are, because of some other commitments, not available to join us today. So with this note at the outset, regarding the center and its noteworthy achievements and the placement and the internship committee of this institution and the USP of our students, they are trained here in a very traditional manner, but their training is, this is what I believe. I mean, of course, I have to sell my students and I have to prepare them that they are no less than, any other student of any other law school in this country. They are taught in an extensive manner. Their training is very autonomous in a sense that, they learn several things. They learn the politics, they learn the law, they learn the they socialize, with their cohort and learn different disciplines. So it's an interdisciplinary place in nutshell, This is what I would say. Now, I think that Samriddhi, I need to introduce our guests before, anyone will take over. I would like to take this opportunity to introduce to this august audience our esteemed guests for today. We have Ms. Nandini Khetan. We have Mr. Sahil Kanuga. We have Mr. Abhishek Dwivedi and Mr. Ish Jain. All of these, stalwarts of their respective fields are an inspiration for our students. And I definitely take this opportunity to extend a very deep thanks from the core of my heart on behalf of the institution, on behalf of the placement committee for joining us today. Their brief profile is definitely, circulated among the students, but I will take 2 more minutes to quickly introduce them. Ms. Nandini Khetan is a partner at Khetan and Company, and her area is basically dispute resolution. I also read somewhere that it is IPR too. So it is something which is very close to my heart. I am an IPR teacher and environmental laws, right? And she has studied from Columbia Law School. Her master's is from Columbia. She has done her bachelor's degree in law from Calcutta University. She is an extremely skilled lawyer and was featured in 40 under 40 business leaders for 2022 by Economic Times. She also served as an external member of the Internal Complaints Committee set up under the Sexual Harassment of Women at Workplace. That is Sexual Harassment of Women at Workplace Act 2013. We have another esteemed guest, Mr. Sahil Kanuga, who co-heads the International Dispute Resolution and Investigations practice at Research and Strategy Driven International Law Firm, that is Nishit Desai Associates. He is a learned counsel with a demonstrated history of helping clients achieve an efficient marketable resolution to various complex disputes. He is known for his analytical and meticulous approach aimed to reach his client's goal. Mr. Sahil has worked on an array of complex matters, including Indian and international arbitrations. He is part of Asia Advisory Committee of the American Arbitration Association International Center for Dispute Resolution, and also a member of Singapore International Mediation Center's Specialist Mediator Panel, India. He aggressively tackles the challenges presented by each case, legal, financial, or otherwise, and has advised on corporate and commercial laws, civil and constitutional matters, and criminal offences. He is recognized by Legal 500 for an enviable track record of representing clients, probing indecorous conduct, whistleblowing, and other company law breaches, in addition to strength in civil and indigenous law. Welcome, Mr. Kanuga. We have Mr. Abhishek Dwivedi with us, the young guest who is graduate from Dr. Ram Manohar Lohia National University, Lucknow, and he started his career in dispute resolution practice of economic laws practice, Mumbai in 2016. He worked in the dispute resolution practice of Cyril Amarchand Mangaldas, Mumbai. At Cyril Amarchand Mangaldas, Abhishek amassed experience in handling high-profile arbitrations, white-collar crimes, including FEMA adjudications, as well as commercial and regulatory disputes involving one of India's largest airports and media licensing agreements of India's premier sports body. Abhishek presently practices before various fora, including the Allahabad High Court at Lucknow, Bombay High Court and other subordinate courts, regulatory bodies and tribunals in Uttar Pradesh, Rajasthan and Maharashtra. He has been involved in advising one of the premier infrastructure special purpose vehicle in the state of Uttar Pradesh on contractual disputes, alongside appearing in multiple arbitrations for and against government bodies. Welcome, Abhishek, to Law Center 1. We have another guest, Mr. Ish Jain. Mr. Ish is senior partner at Regus Legal LLP. He also worked as an independent counsel at the Bombay High Court. He was associated with few of India's topmost leading law firms at the beginning of his career. He is an independent arbitrator and has been empaneled as an arbitrator by the Bombay High Court. He has been working for international clients at the Indian Dispute Resolution Center, International and Domestic Resolution Center, Forum of International Conciliation and Arbitration, and Bihai Asia International Arbitration Center, Singapore, to name a few. He possesses rich expertise in litigation, civil, criminal, and regulatory and arbitration across diversified areas of banking, finance, corporate, commercial, real estate and construction, and technology. In 2022, he was recognized as an Indian rising star by Asian Legal Business. He also featured in Forbes India's list of top individual lawyers about 10 years of experience in 2021. So we have esteemed guests, with rich experience today, and it is definitely our fortune that we are joined by such worthy and notable experts of this field. I now welcome all the students and my worthy colleagues. I see some of my colleagues have joined. So thank you so very much, all esteemed colleagues, for sparing time and joining us today and encouraging our students by your august presence here. Over to you, Samriddhi. Thank you. Welcome all.
Thank you so much, sir, for introducing us, our committee, our center, and most importantly, our guests for the day. We are very delighted to have all four of us with us, and thank you so much for agreeing to be a part of this webinar at such a short notice. It was merely an idea that we should have a webinar on this, given that final year law students have it as a paper. We have a paper, alternate disputes resolution. So this webinar has been planned keeping in mind to explain the students what is actually ADR and what is the career in it. What is the scope? Because primarily in our faculty of law, the focus has been on litigation aspect. What are its contemporary practices, scenario, and if it is actually a viable career at our disposal. We will be leaving our faculty of law in just a month. The 3 years journey is going to end in a month. But before we step out, we want to know about all the possible careers that are at our disposal. Now I request our honorable guest for today, Ms. Nandini Khaitan ma'am, to highlight and speak on the topic, which is career and scope of ADR in contemporary times. Over to you, ma'am.
Thank you very much, Samriddhi, and thank you to Law Center, to Faculty of Law for inviting all of us to speak today on the subject of ADR. And thank you, Dr. Ashwini, for your very in-depth discussion, and we can see the passion that you have for your students and the Faculty of Law, and it's really good to see that teachers mentoring their students so well. I think ADR, as everybody knows, is alternate dispute resolution. Largely, when we talk about ADR, we mean arbitration and mediation. I want to just put this in context of why this is important in the case of India. So let's just step back for a minute on, so we all know about the delays and all, but just want to put this in context. If you look at the national, let me just tell you the right name. If you look at the National Judicial Data Grid, it's a very handy website. I encourage everybody to go on it. There are over 4 crore cases pending in the various district courts of India. Of those, I tell you, there are about 60,000 cases that are 10 to 20 years old. There are about 11,000 cases that are 20 to 30 years old, and more than 40,000 cases which are over 30 years old. 52% of this 4 crore pendency is in the stage of evidence, if I'm not wrong, which just means that, and what does it mean about evidence? You have to give your evidence in, if there's oral evidence, you have to give an examination in chief, somebody will cross you. And I can tell you that having done original site practice, and we'll come to that in a bit, trials go on in courts for years. So once we had a cross-examination of a witness over 2 years that went on, because sometimes the court wasn't sitting, sometimes the advocate wasn't available, the adjournments, witness wasn't there. It's a long process, and it just goes on and on. So can you imagine the kind of delay that one sees? 4 crore pendency is not a small number. Then if you look at the High Court pendency in India, it's over 50 lakh cases. If you look at that 50 lakh figure, over 30 years, I think there are about 13,000 cases which are over 20-30 years old. 75,000 cases are between the aging of 10 to 20 years. And it's a very difficult number to really comprehend. In this, so if you imagine there are two people who are fighting, at the minimum, you need a plaintiff and a respondent. Just imagine how many people are immediately affected. And most cases have multiple plaintiffs and multiple respondents, at least if you know plaintiffs. There's a large number of people who are affected by the sheer delay in the judiciary and the litigation system that we have. The ease of doing business that the World Bank used to publish, which I think has recently been paused for some time. In 2019, if I'm not wrong, India came to the rank of 62 in about 190 odd countries, which was a huge jump from the previous years, single window clearance and all of these heads. But do you know how this used to be calculated? So there were multiple smaller criterias, and then those would be sort of looked into and averaged out to a larger thing. The enforcement of a contract, which is one of the criterias, we were 163rd or something in a 190 country list, and that brought down our rankings tremendously. Imagine if we were a lot higher in the rankings, maybe in the 20s or 30s, where we would have been as a potential investment place by the foreigners for foreign investments in India. So it's really one factor, enforcement of your rights, your contracts, have a downstream effect in ways you cannot imagine. District courts largely also look at marriage laws, personal law cases. The pendency on those are staggering, which effectively means people cannot move on from their current situation in life because the hearings are going on. I was personally handling a case which started I'm talking about a recent matter, it started in 2016. Though of course I'm keeping marriage away from the ADR scene, but I'll come to it, why I'm mentioning this. 2016 the case started. We have finally wrapped up, again through settlement, the case now in 2022. It's taken 6 years, the couple hasn't moved on. It finally settled with mediation in the end in the last year. This could have been avoided if the systems were in place and systems moved on. So this really sets the context of why ADR is important. I'll just take one more figure here. There was a particular case that we were handling, which started in 1990 or 1991, I cannot remember for sure. It finally finished with multiple rounds to Supreme Court and back, execution proceedings, stamp proceedings. I mean, the entire litigation with all its offshoots finally wrapped up in 2018. It was litigated for 28 years between, I would say, roughly 15, 16 parties. And 3 sets of lawyers had handled. So you can imagine, and not every litigant has the money to litigate for those many years. And this is really the backdrop and the context that we around ADR is very important and should by incoming students, practitioners and all of the bar. In India, dispute resolution, first the word was litigation. It was simply called a litigation lawyer or litigation. Now the term has been expanded to dispute resolution because we are also putting in arbitration and mediation as a part of the larger term. And so, you know, even then, unlike some of the other more matured, financially mature jurisdictions or the first world countries as we so called them at one point, you know, there is a very specific arbitration bar that exists. Those lawyers and practitioners only do arbitration. In India, we have not come to that stage where people are just doing arbitration. Most of the lawyers who are doing litigation are ones who double up as arbitrators or arbitration practitioners. The idea is to evolve to a place where we have a separate bar, or there is a bar that parallelly only looks at arbitration while there is a bar that looks at litigation. And this will of course speed up the process of arbitration as well, because currently what tends to happen is that arbitrations largely take place post-court and on weekends. Imagine if arbitration was done through the day like a regular court process every single day of the week. So this is the concept of that there's litigation and arbitration happening parallelly in the today's legal, judicial and legal scenario in India. And at some point we are moving towards the parallel arbitration bar. What I would also like to say here is that why is arbitration? So, you know, very recently someone asked me that there is a Section 9 petition, there is a section which is for interim reliefs in the court, where there is an arbitration clause. There is a Section 11 proceeding of the Arbitration Act, which is basically to appoint an arbitrator, which basically goes to court again, the court appoints. Then there is a Section 34 challenge, which is also in High Court, and then a 37 from the appeal from the challenge. So how are we really benefiting from going to arbitration? We're still ending up in court so many times. But you know, there's an answer to this, which is really very simple. When there is a pure litigation matter which starts and ends in High Court or any district court for that matter, you still have all of these proceedings anyways, except for the Section 11 perhaps. You'll have an application for interim reliefs, you'll have a challenge, you'll have an appeal, you'll have execution proceedings, you'll have miscellaneous applications. All of these take place along with the fact that the trial of the main case takes many, many years to actually happen. So if you file a case, commercial courts have been set up recently, and they are trying to fast track matters. But most of the cases that the backlog that we are seeing in that 4 crore number in district court is mostly regular suits, commercial or non-commercial court matters. So if you see those matters, the trials take many, many, many years. The benefit of an arbitration is that at least that part is cut short in the timelines. You may still have all the other applications that end up in court, the 9s, the 11s, the 34s and the Section 11s, but you're cutting short the actual trial time. That is the real benefit of arbitration, for which everybody should consider going in if it's possible, if there is a clause to arbitrate. And let me also tell you my personal favorite reason for arbitration. It's far more predictable. You have timelines in place, you have expectations in place. Sahil will agree with me, and so will Abhishek, I'm sure, when I say that, you know, the unpredictability of the litigations is quite nuts. Our friends and family suffer the most because we cancel all kinds of commitments because a matter has suddenly turned up or got listed, because the list only comes out the previous evening. So we are scrambling one day before or one evening before in most cases to go and prepare for a matter that suddenly got listed in the next day's list. Sometimes when it's specially listed also and it's not heard, it'll keep running in the list and you have no sort of eyes on when it will actually turn up. The sort of predictability of arbitration and your schedule because of that makes your preparation and the delivery efficient, I feel. For those reasons, I think ADR, arbitration part of ADR is very, very important. I'll also take 2 minutes to just touch upon mediation. Mediation has becoming, well, the Indian society always had the concept of mediation inbuilt because, family members would mediate of society, the respected people of the society would mediate any two people's problems, whether it was family problems or whether it was contractual. Mediation has, because it was not binding, it had really a little effect from people who had nothing to lose from, sort of rejecting the outcome. But it is taking a lot of, it has gained a lot of momentum in the last 5-7 years. The Delhi Mediation Center and the Bangalore Mediation Centers are, I think, sort of forerunners in this case. The Delhi Mediation Center, I'm just quoting from their website, I saw they had about 1 lakh plus cases referred to them for mediation, and approximately 59,000 of them were settled. And that's a really big number. Now, I don't have the timeline in which they were settled, but they were settled, and I think the 50% number was, or a 60% success rate is also for the Bangalore Mediation Center. So mediation is fast becoming something that's seriously as an option these days. And I think if we do have a career in ADR, I mean, if the students who are passing out today, when they take up litigation, one of the things that they should they should look at the fact that arbitration is something that makes the litigant's life a lot easier in terms of timelines. And if we develop, for the people who are already in the system, it would be difficult to just shift to sort of an all arbitration practice. But the people who are passing out, they should keep in mind that they should encourage, and one of the ways to do it is to put in more arbitration clauses in your contracts at the time they are being drafted by your corporate lawyers, or if you're doing the drafting yourself. So what I really wanted to talk about was the context of why ADR is important. And I'll ask your thoughts on the